Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us Travis Cross. He's a lawyer and receiver. Welcome, Travis.
Thank you, Melinda. Thank you for having me.
I'm so glad you're here.
I am too. It's a great opportunity to talk about receivership.
So let's tell everybody, what is a receiver? I don't think the average person knows.
And often they don't. So what I like to tell people is a receiver, for all intents and purposes, and it's completely determined by the court order, but we basically step in the shoes of the owner whenever selling a property, managing a business. And I specifically focus on real property, so residential, commercial. And what it means is I get appointed as a receiver. I can prepare the property for sale to increase its fair market value. I sign the listing agreement, the contracts, the amendments. I even signed the closing paperwork.
Okay, so let me interrupt. How is that different from a realtor? Because we're all used to hiring realtors.
Correct. So with a realtor, they don't have that power to actually sign these documents. And what you often find in family law cases or other cases where a receiver might be necessary or properties involved is that a realtor will send out a listing agreement, but husband who doesn't want to pay wife a dime refuses to sign it. And at that point, the realtor can't list a property. And then even if you get past the initial, okay, we got their signature for the listing price. Let's say the realtor overestimated what a property would sell for and it's selling for less. Husband or wife isn't happy, so they may not show up to the closing table. And at that point, you're, dead in the water. You can't.
So when you said you step in the shoes, the person who might have been selling it, the husband or wife in our example, you are now the person selling it.
Correct.
On their behalf. And you have a fiduciary duty, I would assume, to them, right?
Correct. So the fiduciary duty is to maximize what they receive net proceeds wise. But at the end of the day, I like to just clarify the owners are not my client. I am just a court officer that's basically been appointed to sell this property. So the listing agreement, and I have my real estate license at Compass. What every listing agreement has is their name and then my signature, and then under it says Travis Cross is signing this on behalf of these sellers pursuant to this order and this cause number. And even whenever it comes to executing a contract, it has that same language. And we even write in the special provisions that this contract between the buyer and the sellers it's pursuant to court order for its approval. So the buyers are fully aware that this is in receivership and we cannot sell it unless the court officially approves it.
So it's overseen by court, and you have to take steps throughout the process to get court approval, true?
100%.
Have you ever not gotten court approval?
No. So in the beginning, I was fortunate enough. I did family law for 5 years before doing this, and I represented a few receivers where I didn't know what a receiver was. So I had to figure it out. I had to, just try and find out what we need to do to get this property sold. And luckily, my mom, Leanne Diamond, which a lot of people in Dallas know.
I have known Leanne a long time. She's an excellent lawyer.
She has been doing this a long time. She's dealt with receivers, and she basically just sent me what she's seen filed in other cases. And so I got to review that, break it down, and see what we need to file with the court, because the order appointing receiver is one thing. Getting it listed, I can do all that without additional court approval. But whenever I execute a contract, I have to submit that to the court. So the parties, if they have any issues with the sales price, the terms, if they want, a lease back or an extension on moving out, that's their day in court to say, Judge, I don't agree with this price.
I see. So I, as you know, serve as a mediator. So I mediate only in family law, but I often put in my mediated settlement agreements, with the consent of everyone, that if they're going to have language about selling a property, which is common, like they agree we're going to sell the marital residence, and maybe it'll sell before they get the decree entered, but if not, then they're going to have all these terms in the decree. And I always say, upon either party's request, a receiver shall be appointed. Is that the proper thing to do?
100%. Because if you don't have that, you might be dead in the water again one day when husband or wife doesn't want to sell it and someone has to do an enforcement of the MSA or the order. And if it doesn't have that language, I've seen judges say, well, I can't do anything about appointing Mr. Cross as a receiver because I don't have the authority. And, you're active in family law and
Mhm.
practicing, and I'm not anymore. But from what I've seen, you have to kind of pursue it through collecting a judgment at that point. And then
Oh, many more hoops.
many more hoops. And it's sad because I've had $12 million, $10 million properties where they just don't have that language in the final decree. And the wife's sitting there saying, I'm supposed to be paid. I owe my attorneys money. Like, I don't know what to do. And a judge at that point is like, I can't do anything at this time.
Oh gosh, so that's just one sentence we need to be sure to include.
100%.
How is a receiver paid compared to a realtor? And could you have circumstances where you have both? The receiver needs to hire a realtor in some instances.
Great question. So I'll start with the how receivers paid, and then, in different instances, what
Mhm.
happens. So in my practice specifically, what I do is I charge the standard commission. It's included in the court order, the realtor commission, which these days is still 3% to the selling side, and typically 3% to the buying side as well. But the court reviews that, determines that. And then a good way to think of it is anything in the realtor capacity, showing the property, negotiating, doing, what a realtor would normally do, gets paid for by the commission.
Okay.
But if I'm going to be doing stuff outside that capacity, like, for example, whenever I get appointed, I go file the receivership order in the deed history for the property.
Yes.
So if anything happens, if a lien gets put, they're aware that it's in receivership. That's something 100% out of the normal realtor capacity.
Right.
And I and I bill hourly for that.
I see.
Going to a property and basically serving as the intermediary that says, okay, this court order says you get this, and this court order says you get this. So y'all play nice and take your stuff and, vacate the property. That's where I would bill hourly for stuff
see.
outside the normal realtor capacity. And then to your second question, are there instances where I work with a realtor because I am an attorney, I'm a realtor, and what I combine the two into receivership? I normally will list a property myself if I am familiar with that area.
Okay.
So Dallas proper, I work in Austin now as well. So the areas around Austin, but I've been appointed for properties on the border of Mexico, New Mexico, Arkansas, and Louisiana. And I will find an agent in that area that's qualified to actually sell the property. And I will have them serve as the realtor, and they will send me the listing agreement. They will send me the contracts. They'll send me comps. They'll send me everything you would send an owner in that capacity. And I just serve as the owner in getting these properties sold that I'm not familiar with in that area.
And how is the realtor compensated? And how are you compensated when there's both a realtor and you?
So they get their 3%,
Okay.
and then I just get my hourly.
I see. I see. So
Mhm.
it's really the same difference from the owner's perspective, the actual owner.
Correct. Yeah. I mean, in a sense, the owner, if they could make hourly on it as well, that'd be
Yeah.
great. But, it really is kind of the last resort where a receiver does get appointed, and it's necessary because, receivership can be expensive. Outside my commission, I've had cases where I get paid $1,500 to file motions and go get everything approved. I've had cases where I get paid $70,000 from my realtor or my receivership commission alone because it's so litigious and multiple properties, like 10 properties, 10 different appearances, having to file a TRO against someone that's not doing what they should, which very popular in family law, especially on a Friday.
Friday before holiday.
Exactly. So it is more expensive, but it's kind of the monster you make it. You either start playing nice and this will be cheap and easy, or if you don't play nice, then it's going to be expensive. For
Yes.
example, yesterday I had to go to 3 properties, change locks at all 3 properties besides one. And the one I didn't change the locks at is because whenever I arrived, this person who I've posted notice on their door, I've emailed them, I've called them. They had 2 dogs there, and they were there. And I'm not going to force them to leave with pets. And basically, he was the whole husband, that ostrich in the sand situation, doesn't want to deal with the case at all. And so I sat down and talked to him for 2 hours about what's happening, what's going on. and kind of working on next steps to help him open the next chapter of his life.
Oh, that was nice.
And then I've had situations where people pull a gun on me. So
That's not as good.
yeah, not as good. Sometimes it's great, sometimes it's incredibly scary.
Yes. Well, to your point, we would never have a receiver if everybody acts like adults and does what they're supposed to, right? So in my languaging, we're saying the parties agree they're going to sell the marital residence. And here's all the terms. They're going to either set the terms in the MSA or in the decree, or they're going to say, we have to agree on the sales price. We have to agree on the agent, da 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 da. But if somebody won't agree, sticks their head in the sand, just doesn't want to be helpful, then upon request of either, a receiver is appointed. So you come in when there's already a problem.
Mm-hmm.
They do not agree. They either have a legitimate, possibly, dispute about sales price because somebody is delusional and thinks it could sell for a lot more, or they don't care if it's sold.
Right.
So they want to overprice it because they're living in it. They don't want it to sell, or they won't show the property. Then we have to have you come in.
And I would add, like in this MSA, something to consider
Yes.
is yes, do the court shall appoint a receiver, but if you also include language in there that says, and it's just a different way to do it, but the realtor has the decision-making authority if the parties don't agree regarding sales price. The parties are ordered to comply within 24 hours from the realtor's request. If you include this little language in there that actually is the power of a receiver, the title of realtor is just a title, but you still have that receivership language. And what I've done recently, is had to file my own motion to clarify an order and to officially appoint me as the receiver, because it says I'm the realtor, gives me the receivership authority, but the parties, for example, refuse to clean the property and they wanted to use AI to make it look presentable. And I'm just like, guys, come on. This property's being sold. Like, let's do it right. Let's get the highest sales price.
Yes.
And they're like, well, we're going to get the highest sales price, but not by listening to you. It's like, okay. So I call the attorneys and they're like, yeah, they want to go with someone else. I'm like, I have this language that gives me the receivership authority. So I'm doing exactly what the court appointed me to do. So I filed the motion to clarify, and it should be heard by submission in the next week or so. So
okay, well, I'm going to get some good language from you so I can add to my sentence.
I have an order that originally was a page long that's now 8 pages long. So it's tried and true. And actually, Hunter Lewis actually helped me draft the very first order. So shout out to your firm. Shout out to Hunter. And it's grown so much from there. Like, for example, the 24 hours to comply with the receiver's request. What parties sometimes will say is, well, we receive a showing request, but it has to be 24 hours from now because that's what the order says. I'm like, okay, are you just doing this to be a pain in my side? Or are you doing this because like you work from home? And sometimes it's just to be a pain in my side. So I've developed the order where it's like, yes, 24 hours to prepare a property, respond, etc., but also 2 hours to comply with a showing request.
Right, because when you're trying to sell a property, when somebody's available to look at it, you need to show it to them.
Yeah, and I think a lot of people like don't realize that when an agent submits a showing request, it's usually last minute. It's usually the day they're with a party.
Yes.
So if they have to wait until the next day,
you may lose it.
Exactly.
And they're never going to come.
And you have buyers that fly in town or only in town for the day. So it's just that order is something that has really grown and developed over the past 4 years.
Yes. Okay, give us an example. Tell us some stories about the life of a receiver.
Well, you heard the gun issue. But so it's 2026 now. Last year, 2025 was the year of the crazies. I had just the most complicated, difficult cases. I had one case with a racist woman who, when she found out the buyers were Indian, left raw pork and wrote slander stuff on the wall before she vacated.
That's so sad and discouraging to me. What is wrong with people?
That's family law. It's like,
oh my gosh.
I mean, you can correct me if I'm wrong, but that's people acting on their worst behavior.
Yes, that's true. That's a good way to think about it. So you don't lose all hope for the world.
Well, yeah, and hopefully you get lucky with, the right one. And then I had a case where we went to a property, someone pulled a gun on us, and then he called the judge threatening his life. And I guess what he didn't realize is when you make a threat to a federal official, it's a felony, I'm pretty sure, and if not more. And now he's serving time. And
Wow.
yeah,
I never had anybody threaten the judge. I did have one where this man was kind of a witch doctor,
Hmm.
and he wrote a long diatribe about cursing me and cursing the judge and cursing the eyes of our children. And I was a little anxious.
I've had a similar case for a receivership where we went to the property and there was writing on doors, on windows, a candle like being burned. I'm like, what's the deal here? And he said, oh, my wife and I practice witchcraft. I was like, okay.
Now we're going to have to bring a priest to
Yes.
cleanse the building.
Yes. Are there any ghosts that we have to disclose when we sell this property? But I mean, receivership is kind of like family law. You never know what you're going to get. You think you've seen everything. And then this one case just blows your mind. There was a receivership where the owner, died of a fentanyl overdose in the front yard. And the buyers, I'm like, do we have to disclose this? Like, because she didn't die on the property, she died
Right.
outside the property, and
Right.
it's never stopping. But what I find is that with attorneys that kind of need help on getting a property sold, getting their client the proceeds they need, receivership, even though courts say is like the last option you should consider, you should always include that language in the order because you want to make sure that, this main equity that your client might get or will get
Yes.
is sold. And, Dallas has been known to have receivers here. So, most attorneys know about them. But for example, in Austin, excuse me, I receivership is not something that they've like ever did in Travis County.
That
And
is so crazy to me.
yeah, and there was a case I was appointed on in January where during the divorce they had 20 properties, they sold 10, and the divorce was finalized in 2022, but there's still 10 remaining properties, and these properties have been sitting for 4 years, nothing happening. And
But except incurring property taxes.
yes. And it was funny on that case because the husband wanted reimbursement on, I've paid 4 years of home insurance, saying,
Yes.
with my order, it says I have the authority to contact, mortgage companies and do X, Y, and Z. So I call the insurance company. I'm like, hey, I'm just verifying, what's been paid. Sometimes whenever I get appointed as a receiver, I receive money in trust to like take care of these properties.
Yes.
And they're like, oh, yeah, that got canceled due to non-payment back in 2022.
You're like, dude, you didn't even pay it.
Yeah. So
Good thing they didn't all burn to the ground.
Exactly.
Oh my gosh, that's so horrible. What percentage of your receivership practice is family law related?
It's about 80%, I would say.
Mm-hmm.
Then another 10% is probably probate, and then the remaining 10% is completely random. There's I've been appointed for probate cases with $5,000 lots of land in Anna, Texas. I've been appointed for family law cases with divorces involving a property in Preston Hollow for like 10 million.
Mm-hmm.
And then I was recently appointed on a case where the owner isn't paying GCs what they're owed, and that's for a luxury development, and that is going to be a huge undertaking. But I mean, that's from a simple, non-payment to the GC, simple civil case.
Meaning the general contractor.
Correct.
So they've been hired to do all this work. They're doing the work and nobody's paying them. Oh
Correct.
my goodness, that would be stressful.
Yeah.
So how does it come up in probate?
So with probate, you have really the estate has this property, and then one of the attorneys will file it just as you would in family law
Uh-huh.
to sign off on behalf of the heirs, and that's usually only necessary if they say, yeah, there are heirs. We don't know necessarily where they are, but there are heirs, and what the court will do is authorize the sale, and then the court will simply hold the proceeds in trust or in my trust or in the court's registry.
Uh,
And then when the case is finalized, they will disperse to the heirs from that point.
Oh, so they don't even have an heir to try to work with to sell the property.
Correct. Like, and when I'm appointed as the receiver, acting on behalf of the owners, technically, a bunch of unknown heirs might have ownership to this property. So I sign off on everyone's behalf to get a property sold.
Okay, so let's say you're selling a property in family court or in probate court. Let's do family court.
Okay.
And you know who the people are. They're existing people we know. They just aren't cooperating. Do you still go to them and say, hey, I think we need to drop the price? It's really your decision, but are you trying to get them to give a little buy-in?
I think if you can get involvement from the owners, especially from early on, it's helpful in determining, listing price and, what have you done to the property? What have you changed? Have you remodeled it? Getting that information early on to really decide what's a list of property for. And then I will send out, this is what we've decided. Here are the comps. And this is, most likely what we will list it for, but please give me your feedback so I can review it in preparation. And then I review the listing price for property every month. And if there's changes in the market to that area, I'll reduce it to match the area every month, every 2 months. It just depends on what's happening in that market. And then I will email them, hey, this is what I've seen. This is what we're going to change on the listing price. Please let me know your thoughts. And I'm always open to feedback. And, there's times where I might miss something. Like, for example, if you go under contract or about to go under contract and a buyer's asking, when was the roof replaced?
Right.
Well, how the heck am I going to know that being a receiver? So having an involvement from the owners, like, when was it replaced? And they give me that so I can relay that.
Okay, so it is good to have a good relationship with them if you can.
We try.
Yes. What do you do? Have you ever had somebody try to remove you once you're already appointed? How does that work?
So that would be a motion to either substitute or remove the receiver. And a receiver typically gets appointed at temporary orders, at mediation, or final trial. And this stems from people not agreeing with the sales price, a property not being sold even though adjustments are being made, and then also because the sales price, the adjustments, that's when people will move. It doesn't happen that often. I think it's probably happened 5 times in the past 170, 180 cases I've done in the past 4 years so far.
Yeah, so it doesn't come up very much.
But it's never been granted.
That's good. The judge is like, nope, carry on.
Yes. Those crazy cases that I was on last year, each one of them filed that. I'm like, Judge, this is why they're upset. This is what I've been doing. This is what the market's doing. So I'm going to respectfully ask this court to deny their motion. And it always has been denied.
Are the judges in the Dallas-Fort Worth area and in Travis County, are they pretty knowledgeable, or sometimes are you educating the court?
It's hit or miss, I think a lot of judges know kind of what a receiver is, but whenever it comes to real property and the ins and outs, the process of whenever I go under contract, I have to submit a report for everyone to have their day in court. They might not know that because historically receivership has kind of been this like gray area, especially in the state of Texas. And it still kind of is the Wild West. Like, when you're appointed as a receiver, you have a lot of authority. You have so much power over this property and what the proceeds. And there's even been title companies that will sell a property without getting official court approval.
Whoops.
Yeah. So
let's do it right, people.
So yeah, you have to do it right, and you have to just follow the proper procedure. And I think I can say that I'm probably, the most trusted receiver in the state of Texas, and most knowledgeable. And I trying to say that as humbly as I can. I really care about this, and I really think that having, a good history and the credentials and credibility really go into the receivership work. And I'm very proud of what we've done in the past 4 years.
And this is 100% of what you do. Is
100%. Well, remember what I told you earlier? We had a family member that had a family law issue come up.
Yes.
And so my wife was representing her, and my wife's like, do you want to just come on board and do it with me? I was like,
except
sure.
for helping family, family friends occasionally with their divorce.
Yes.
So, are you familiar? Are there other people in town that also have 100% receivership practice?
There are, but there's not very many.
No, I'm not familiar with very many at all.
The only person that I've ever been impressed with whenever it comes to coming to me with receivership
Yeah.
questions, because these realtors will come to me and say, "What do I do? Where, like,
Yes.
the court just appointed me. I don't know what to do." There was a woman in Waxahachie, and I can't remember her name, but she was very knowledgeable. And the only issue I saw in her practice, which I actually told her she should start doing this herself, but she wasn't an attorney, so she didn't know the motions to file, the orders to
Oh,
draft to
yeah.
get
Yeah.
signed, how to perform a hearing if it's contested. And so she had an attorney helping her on that. And I said, the motions and orders are pretty straightforward. After you've been to court 5 to 10 times, you should know kind of how it's got to go.
Right.
But that's the only person locally that I've been super impressed with. And
Mhm.
then Travis County, it's no one. Like, I have met one person that's done 5 receiverships over the
You
course of
you're
20
introducing
years.
it to Travis County. It sounds
Yes.
like we're
And
here to help you have receivers.
yes, please help me. Please have me help you. That's all I want to do here. But it's really hard because, receivership, you do have all this power. And, there's people that have connections with mediators and referrals from that. And that, receivership should just be, you should have your name in the Rolodex, or the wheel that the court has, and do a really good job, and, earn that trust of the attorneys and the judges and mediators moving forward.
Well, you have an excellent reputation, I can say,
Thank
in
you.
the Dallas area and probably all over Texas. Do you ever do anything outside of Texas?
So there was a case with a firm here in Dallas where there was a Florida property, and they asked for me to be over the Florida property, but the court decided, like, we don't want to have Travis fly down there and fly back. So they used a realtor there that, I basically explained to him the receivership process. But every state has their own rules, but I think it's pretty much the same across the board. It's like, you own or lease property in the state of Texas, you're a qualified voter, you have no interest in the property, and you can be a receiver. So,
So you can't be a receiver on your own property.
correct,
Because
because
you
you
don't
have
need to
you
be.
have an
You're the owner.
interest. Correct, yeah. And at that point, it's, if I was getting divorced from my wife, which pray to God never happens, it would be, I need to be on my best behavior because I know what a receiver can come in and do.
Yes.
And
Just act right. Sell your own
exactly.
property.
Yeah, but unfortunately, there's, people that just don't care.
Well, and we have all had cases where maybe our client's acting right, but we can't control the other side.
Mhm.
So it's good to have, that's why we need judges. That's why we need receivers and people appointed by the court to help, is sometimes you can't get a crazy person to do what they need to do.
Right.
So how can people reach you? What's the best way?
So I have my website. It's LRECG.com. So Lima Romeo Echo Charlie Golf.com. I have my email, Travis at LRECG.com. And then you can call me at 469-525-0087. But I always prefer email just so I can keep track of everything, especially with
Yes.
all the spam calls we get. And
Yeah.
um,
Email's the best way.
100%. And if you're represented by an attorney, they might already know me, and they can just, I always like going through the attorneys first, because I have a form, receivership what to know, a 5-page document that explains everything. I have my motions and orders that are tried and true so far, that aren't just Travis Cross is appointed to sell this property. It's very thorough language. Says Travis Cross can sign the listing agreement, the contracts. Travis can call the mortgage companies. So if an attorney contacts me, I can give them the forms, the motion and order. And from there, whenever I get appointed, I just kind of take on the case. I like to communicate directly to the attorneys and just have everything relayed to the clients. But yeah, have your attorney call me, or you can call me and we can talk about what's going on.
Excellent. Thank you so much.
Thank you.
This was very helpful. I think will help people. You just need that one sentence at least, that a receiver shall be appointed. That's our takeaway from today. Thank you so much for watching You know a little bit more now about how to make things happen when people will not cooperate. Thanks for tuning in, and please tune in again next time.